guys, how are you all? I hope all of you are well, life is well, and you are well, and everybody is well. Hello, 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 hello. How are you guys? So today we are going to be doing legal current affairs from this particular week. Let's see what has particularly happened, and we are going to be talking about the same. Hello, 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 hello. This week's legal current affairs. Hello guys, all right, so let's start. Before we start with that, let me tell you about our MHCET course, which is the crash course. Any of you preparing for MHCET and want to have a more dedicated preparation with classes, with courses, with concepts, as well as practice with sectional tests and mock tests and doubt sessions, everything will be done in this particular batch. You can use my code Kriti B. We also have a batch for CLAT, which is Aram. So anybody of you preparing for CLAT examination, then you can come and study with us and you can complete your courses from the comfort of your house. All right. Hi. Hello. Let's start with the first news this particular week. Section 7 POCSO Act. Squeezing and pulling breast of minor girl without skin-to-skin contact amounts to sexual assault. Very important decision given by the Odisha High Court. So Odisha High Court has decided this particular case. Always remember that it is important to determine what is skin-to-skin contact, because that determines the liability of a person under POCSO for sexual assault, right? So POCSO is a law that has been made for prevention of children from sexual offences, to help children that they should not be getting into sexual offences and they should be protected from the same. Therefore POCSO was created, and if any person is found to be liable under this act, there are very harsh punishment for the same, and so therefore it is important to determine what is going to be sexual assault. So sexual assault basically means skin to skin contact. Now skin to skin contact can have different definition. A lot of times court has determined what is going to fall under skin to skin contact. So here in this particular case, the question was, if a person touches specific sexual parts of the body of a child, if any person touches sexual parts of a body of a child, can it fall under skin to skin contact? The court has said yes, it is going to fall under. So here what happened was, there was a girl who was traveling via bus. She was seated on the window seat, and when the bus took a halt, the appellant, the accused, approached from outside and squeezed and pulled the breast of the victim by putting his hand through the window of the bus. So here now he was caught after this, and then a case was filed against him. According to him, his standing was, his reasoning was that this is not going to fall under skin to skin contact, and therefore I should not be made liable. Like she was wearing clothes, so there was no skin to skin that contact happened, but the court said no, this is going to fall under skin to skin contact. Acquittal in criminal case, no bar on employer to conduct departmental proceedings. This is a very important reasoning of administrative law. So what is administrative law? It is an extension of constitutional law, which deals with administrative bodies, which deals with institutions that implement laws. So we have CPC, for example, we have BNSS, for example, which tells us the procedure for criminal cases, procedure for civil cases, how the judge has to decide case. But what about those cases wherein a person's legal rights are getting affected, but it is not the court who is deciding the case? Then certain rules need to be made about the same, right? Those rules fall under the part of administrative law. Now herein the question was, if a person is made liable under criminal law, can there be an inquiry against a person under his department? For example, let's say there is an IS officer who has been accused of bribe and has been sent to jail for it. Can there also be an inquiry against him, that whether he should be suspended or not? Can he say that this will amount to double jeopardy? What is double jeopardy? That I have already been punished once for the same thing, I should not be punished again. So what will be the law applicable? The court has said it is not double jeopardy, because departmental proceedings are not punishment. They are in itself a different proceeding from court. So if the court punishes you once, the court cannot punish you again. But apart from that, departmental inquiry can happen, because that does not form part of department. That does not form part of court making you liable. So herein, therefore, the court said, sorry, we can do departmental proceedings against you even though the court has convicted you. Bamboo stick or rod, not an instrument likely to cause death. Calcutta High Court reduces sentence of the person. So here what happened, a fracture injury happened because a person picked up a bamboo stick and hit another person, and the other person went through a fracture. Now a case of grievous hurt was filed against the person who hit with the bamboo stick. Now, the person who filed the case, the prosecution said that this should not just be grievous hurt, it should be grievous hurt by a dangerous weapon, which is another offense which has higher punishment than normal grievous hurt. But the court said dangerous weapon means something that can kill you. For example, let's say a machete, or for example, let's say a gun, something that can lead to your death. But a bamboo stick is not something that falls under dangerous weapon, and therefore the court said that this is only going to be grievous hurt, not grievous hurt by dangerous weapon. Delay in filing complaint, no ground to discard matrimonial cruelty case. Section 498A is a continuing offense. Now, Kerala High Court has said that if somebody, for example, let's say there's a husband who beats his wife, okay, the wife did not file a case. Now, let's say 8 days later, the husband again beats the wife does not file a case. This goes on for 6-7 months. 6-7 months later, finally the woman gains confidence and files a case against the husband. Now the husband says that I cannot be made liable for cruelty because I hit her the first time 6 months back. Because she did not file a case against me 6 months back, she is in no place to file a case against me today also. ये क्या बात हुई भाई? तो court has said कि see, section 498A is a continuous offense. It is matlab every time you hit the person, it is forming part of section 498A. And therefore you can't say कि case should have been filed the first time only. You can't say कि there has been a delay in filing FIR, and that will not take away the point that you have hit her and you have committed cruelty. So court said that the case will not be discarded. This will continue as cruelty. After husband agrees, Kerala High Court allows correction of father's name in birth certificate of child born out of extramarital affair. So generally what happens is that if a man and woman are married, then if they have a child and the husband is not able to prove that he had no access to the wife, the child is seen as a child of the husband and wife only. Even if the child was born out of wedlock, the court does not care, because the court also has to keep in mind the paramount protection of the child, right? So here in this particular case, there was a writ petition filed in the court of law, wherein a father himself wanted to correct the name of the child, father's name to be changed to the name of the person with whom the wife had extramarital affair and had a child with. So here the case was filed. The question was, can the court allow the same? So court here said that both the parents are okay with it, minor child is also okay with the change of the name, and therefore in this particular case, if the father does not object, father agrees, if the husband, if the husband agrees, if the husband agrees ki okay, now you can change the name, I don't care, alright, then the name can be changed in the birth certificate, in the school certificate of the child. Why hurt Jan sentiments? Acha. So a PIL was recently filed in the Supreme Court. What is PIL? Public interest litigation. So what is public interest litigation? A case that is filed in court of law in which you don't have any locus standi, you don't have any personal interest, but in the interest of the public you are filing a case. So PIL keeps on getting filed in the court for different reasons. For example, let's say a whole lot of trees, forests are getting cut and I am very agitated with it. I can go file a PIL on the same, right? Even though there's no personal interest, but I can file in the interest of the public, that this can hamper the interest of the public. Now a very absurd PIL recently, like last week, was filed in the Supreme Court, wherein a person filed a case saying that Jains don't eat onion and garlic, and therefore a research needs to be done on the same, that is there any tamasic nature in these two particular things, okay, matlab any negative character in these two particular things. Like we also want to know that should we also not eat it because there's something negative about onion and garlic. But the court dismissed the petition. The court did not entertain it at all. Court said it is a vague petition, unnecessary petition, wasting time of the court petition. We don't have time for all of this. We already have a lot of pending cases. Please get out. So court refused to hear that. Coming to liquor policy case, Delhi High Court issues notice. Arvind Kejriwal and Manish Sisodia are once again at issue. Why? So what happened in this particular case? To explain this to you, in 2021-22, Arvind Kejriwal, the then CM of Delhi, came up with a new policy. कोई बड़ी बात नहीं है. Every CM keeps on coming up with new policies. It's good. We can make changes. But in 2021-2022, he comes with a policy called as the liquor policy. So liquor is largely regulated by the government and not private parties. Arvind Kejriwal wanted to change this stand. Why? Because he thought that there will be better consumer experience if there is competition in the market amongst the private bidders, that we want to provide the best liquor, we should get the license to provide liquor, right? And also to increase tax for the government to make the city better. We can do better changes with the tax that we will be able to collect. So Arvind Kejriwal came up with the liquor policy, through which he took away the control of liquor from the government and gave to private parties. Now the biggest issue arises is that a case is filed against Arvind Kejriwal by CBI and ED saying that this is a scam. Arvind Kejriwal and his government was taking bribe through all of this policy scam. This is a liquor policy scam. They were actually favoring certain private bidders who were paying them extra. So there was no fairness, there was no equality. And it was one way to take bribery, it was one way to scam basically, and therefore Arvind Kejriwal and Manish Sisodia were arrested and then taken to the jail. Now, the trial court had to decide this case. What did the trial court say? The trial court, high court nahi hai, theek hai? Trial court is the court which is trying this case, ki whether they are actually liable or not, get us the evidence, etc. The trial court allows for Manish Sisodia and Arvind Kejriwal to be let out from jail and say that there is no evidence against these people, no solid evidence was against these people. And the trial court also makes certain remarks against CBI saying that they were trying to fulfill loopholes by putting in witnesses, by putting in evidences that were not there. So this was basically more of planted against Arvind Kejriwal, and this was wrong and this should not have been done. And they were therefore made to let go. Now CBI got very, very angry with this, of course. CBI filed an appeal in the Delhi High Court. Delhi High Court said that the remarks that were made by the trial court against CBI were unnecessary, were not correct. Those remarks should not be made. We will not allow such remarks to be used as evidence in our court or used as substantiating your point. You cannot use those remarks. They were wrong remarks. And secondly, the Delhi High Court has also sent a notice to Arvind Kejriwal and Manish Sisodia that now, please explain to us that what was the scam about and was it not a scam? How will you prove your innocence? So now again, Arvind Kejriwal has been asked to submit the report to the court. Let's see what the court says and let's wait for the decision. Meanwhile, Delhi High Court has said that the case that was filed by ED will be stayed for now. We will not discuss that. First, we will discuss the case filed by the CBI and then we'll take up the ED case. So for now, तो उनको थोड़ा सा राहत है. Arbitral tribunal cannot grant pre-award and pendant light interest when contract prohibits it. So what is arbitration? We have discussed this plethora of times. Arbitration क्या होता है? एक alternate dispute resolution method है. क्या मतलब? जनरली कोर्ट डिस्प्यूट रेजोल्यूशन का मेथड होता है, पर कोर्ट एफिशिएंट नहीं है ना। अभी भी कोर्ट में हजारों केसेस पेंडिंग है, लाखों केसेस पेंडिंग है। आप केस फाइल करो 10-10 20-20 साल लग जाते हैं केस सॉल्व होने में, एंड इट्स ऑफ नो यूज, ठीक है। सो वी हैड टू पुट अप सम ऑल्टरनेट मैकेनिज्म। जैसे अभी भाई एलपीजी मिसिंग है, तो हमने गवर्नमेंट को क्वेश्चन करने की जगह उसका ऑल्टरनेटिव ढूंढ लिया, है ना। इंडिया में भाई हमारे पास बहुत सही सीन्स हैं, हम हमेशा ऑल्टरनेटिव ढूंढ लेते हैं। पीने का अच्छा पानी नहीं है, कोई बात नहीं, आरओ लगा लेंगे। एलपीजी नहीं है, कोई बात नहीं, हम इंडक्शन खरीद लेंगे। सो वी ऑलवेज कम अप विद ऑल्टरनेट सोल्यूशन। सिमिलरली कोर्ट एफिशिएंट नहीं हो रहा था, तो वी केम अप विद अनदर सोल्यूशन कि लेट्स ब्रिंग अनदर ऑल्टरनेट डिस्प्यूट रेजोल्यूशन, दूसरे मेथड जिससे हम डिस्प्यूट रिजॉल्व कर सकते हैं। द मोस्ट फेमस बीइंग आर्बिट्रेशन। आर्बिट्रेशन में जो जज होता है उसको आर्बिट्रेटर बोलते हैं। पार्टीज केस फाइल करती है और फिर आर्बिट्रेटर इनफॉर्मली केस डिसाइड करते हैं। इनफॉर्मली इन द सेंस टिपिकल कोर्ट नहीं होता, एविडेंस लॉ, सीपीसी ये सब अप्लाई नहीं होता। अकॉर्डिंग टू द कॉन्ट्रैक्ट केस इज डिसाइडेड। इसका सबसे बड़ा पॉइंट ये है कि arbitration can only be done in those cases where in the contract specifically it is written that the case shall be resolved via arbitration. अगर ऐसा नहीं लिखा है तो आप आर्बिट्रेशन के थ्रू अपना केस सॉल्व नहीं कर सकते। क्रिमिनल केसेस आर्बिट्रेशन से सॉल्व नहीं होते, ठीक है। चल, अब यहाँ पे क्या होता है, दो पार्टीज के बीच में डिस्प्यूट होता है जो कि एक कमर्शियल कॉन्ट्रैक्ट करते हैं। कॉन्ट्रैक्ट में लिखा है आर्बिट्रेशन क्लॉज भी है। आर्बिट्रेशन में ट्रिब्यूनल क्या करता है, ट्रिब्यूनल मतलब जो जज थे वो कॉम्पेंसेशन अवार्ड कर देते हैं और कुछ कुछ इंटरेस्ट भी अवार्ड कर देते हैं जब तक केस पेंडिंग था। जैसे मान लो कॉम्पेंसेशन हुआ 20,000, पर ये 20,000 तो मुझे 1 साल पहले मिल जाना चाहिए था जब उसने केस फाइल किया था, जब गलत था वो। पर क्योंकि 1 साल लग गया ये केस सॉल्व करने में, या मान लो 6 मंथ्स लग गए, तो 6 मंथ्स में कुछ इंटरेस्ट भी तो लगना चाहिए। 6 मंथ्स पहले जो पैसा आना था वो 6 मंथ्स के बाद आ रहा है। तो मान लो कोर्ट ने अलाउ किया 21,000 एज कॉम्पेंसेशन, 1,000 एज इंटरेस्ट। अब इसको लेके क्वेश्चन फाइल किया जाता है कि जो कॉन्ट्रैक्ट था जिसके बेसिस पे केस फाइल किया गया है उसमें स्पेसिफिकली लिखा हुआ था कि नो मैटर आउटकम कब आता है, कोर्ट केस कब डिसाइड करता है, आर्बिट्रल ट्रिब्यूनल कब केस डिसाइड करता है, इंटरेस्ट नहीं मांगा जा सकता, आप इंटरेस्ट सीक नहीं कर सकते हो। सो अब यहाँ पे भाई ये क्वेश्चन दूसरी पार्टी ने किया जिसको इंटरेस्ट पे करने को बोला गया। अब कोर्ट ने क्या किया था, मतलब आर्बिट्रल ट्रिब्यूनल ने क्या किया था, सेक्शन 31 को लगाया था आर्बिट्रेशन एंड कंसिलिएशन के एक्ट के, जिसमें लिखा हुआ है कि आर्बिट्रल ट्रिब्यूनल के पास पावर है कि वो इंटरेस्ट अवार्ड कर सकते हैं। बट पार्टी ने बोला कि भाई ये तो तब कर सकते हैं ना जब कॉन्ट्रैक्ट में एक्सप्लिसिटली लिखा ना हो कि तुम अवार्ड नहीं कर सकते या कर सकते हो, तो फिर कर सकते हो आप सेक्शन 31 अप्लाई। यहाँ तो हमने स्पेसिफिकली लिख दिया था कि आप नहीं कर सकते हो इंटरेस्ट अप्लाई। सो द कोर्ट सेड दैट डेफिनेटली इंटरेस्ट विल नॉट बी मेड एप्लीकेबल, क्योंकि यहाँ पे स्पेसिफिकली कॉन्ट्रैक्ट में लिखा हुआ है, तो उस सेक्शन तक जाने की जरूरत ही नहीं है। Attempt to settle dispute cannot prevent police from taking cognizance of a crime. अच्छा, अब इसमें क्या होता है, केस है एक डिस्प्यूट का, एक लोकेलिटी इन पंजाब में दो ग्रुप्स के बीच में लड़ाई हो जाती है, ठीक है। कॉन्फ्लिक्ट began when one group alleged that drainage water was being diverted into their houses. ठीक है, तो दो लोग हैं आसपास रहते हैं, one side is saying that the other party has diverted the drainage, the bad water, the smelly water into their house. So clash started happening and they started fighting. अब क्या हुआ कि वो बहुत बढ़ गई लड़ाई, है ना। जैसे अभी आपने देखा होगा, अभी हुआ था वो बलून फेंकने वाला केस जिसमें गाय डाइड ऑल्सो। सिमिलर थिंग हैपेंड हियर दैट द tensions arose and police reached the spot. The good part is पुलिस वहां पे पहुंच गई टाइम से। अब पुलिस ने मीडिएट करने की कोशिश करी कि मत लड़ो भाई, स्टॉप फाइटिंग, स्टॉप इट, व्हाट आर यू गाइस डूइंग, डोंट डू दिस। However, during this reconciliation attempt, the situation turned violent. ठीक है, जब पुलिस ने उनको बोला कि भाई रुको रुको, one of them brought a gun and started firing. Okay, now shots were fired, caste-based abuses were made against members of scheduled caste community. All of this was observed by the police person who came to check, came to mediate the situation. This policeman went to file an FIR. ठीक है, जो FIR थी वो किसने फाइल करी? जो पुलिस पर्सन थे वो आए थे। अब इस पे क्वेश्चन उठा कि क्या पुलिस पर्सन फर्स्टली हु केम टू मीडिएट फाइल एन FIR फॉर एन ऑफेंस? क्योंकि आप मीडिएट कराने आए थे ना, आपको तो पहले ही FIR कर लेनी चाहिए थी, आप मीडिएट क्यों कराने आए थे? फिर आपने मीडिएट करा दिया तो अब आप FIR नहीं कर सकते। सेकेंडली, instead of people who were involved, can the third person who was a police officer, can that person file an FIR or not? Court said yes, the person can file an FIR, there is nothing wrong with it, because definitely here police person was there to look at the incident and he could have filed the FIR. What is the full form of FIR? First information report. FIR होता क्या है बेसिकली? जो फर्स्ट इंफॉर्मेशन की रिपोर्ट लेके आ रहा है पुलिस के पास कि ऐसा ऐसा इंसिडेंट हुआ है, मैं फर्स्ट पर्सन हूं जो आपको इसके बारे में इन्फॉर्म कर रहा है, दैट इज व्हाट इज कॉल्ड एज FIR। ठीक है, सो अब यहाँ पे कैन पुलिस रजिस्टर एन FIR एंड फॉर सच केसेस वेयर दे वर ट्राइंग टू सेटल द मैटर? यस। ऑल्सो क्या पुलिस ऑफिसर FIR फाइल कर सकते हैं खुद ही, इवन ए विक्टिम ने नहीं किया है? यस। For both questions, the court answered in yes, and therefore FIR can be validly filed by the police officer as well. Mandating menstrual leave may harm women's careers, says Supreme Court. Now, this was a very controversial statement made last week. So what happened in this particular case? A case was filed in the Supreme Court asking for mandatorily making policies for providing menstrual leave to women who are working. So, there were certain asks through the policy that at least 2 days leaves every month mandatorily should be given to a woman for menstrual leave. Now, the Supreme Court here said, Supreme Court has said that it's a good step that leave should be provided to women during their menstruation. But the Supreme Court definitely said about this that when you ask it to be mandatorily given, then the companies may not be interested in hiring women, and that may harm the career of the women than uplift it. To see it from the perspective of an employer, the employer will feel that rather than giving 2 days leave, I will give the job to someone who will not ask for the leave, which is not woman. And therefore, this mandatory leave can hamper a woman's career rather than enable it, and therefore we will not mandatorily provide menstrual leave, but we do ask the parliament to frame policy upon the same. If the parliament wishes to, parliament can form policies upon the same, right? Blood donation ban on gay, transgender person and sex workers retained after review. Center tells Supreme Court. So what has happened? In 2017, government came up with a ban that gay men, transgender people and female sex workers cannot donate blood. Now why? The government says this is purely for health purposes, because we have seen through studies that they are high risk people. They can transfer diseases, especially sexually transmitted diseases, for example HIV. Okay? A lot of people have this misconception that STDs, sexually transmitted diseases, can only transfer through sexual intercourse. No, it is in your blood. It can be transferred via blood as well. So here, therefore, in 2017, the government came up with this ban. Now, a petition was filed in the Supreme Court saying this is violation of right to equality. Everybody should be allowed to provide blood to people who are in need, and it should not be on the basis of gender, on the basis of their occupation, etc. So, court asked the government to explain. The government said ki sir, see, what is the solution? The other solution is ki okay, before somebody donates the blood, we ask them to give some medical test through which we can first determine what are the diseases that they have. If they are found to be having diseases, then we will not allow them to donate blood. If without diseases, they will be allowed to donate blood. But this is a huge process, hai na, at ground level. Not every place where blood is donated is equipped with these tests. First of all, it is a lot of money to be spent also. And it will become very difficult कि before every blood donation the test has to be done, मतलब it will become a huge thing. It's not very easy to be done. That or we make complete ban. We went with the second option and we will not take it back. Center said that we will not remove the complete ban. Now let's see what the Supreme Court says about it. But the government has refused to remove the ban from the same. Right? Parental salary alone cannot decide OBC creamy layer. Very, very important decision this particular week that came up. So what does this say? So there was a person who belonged to OBC category and was not given reservation because it was said that he belongs to non-creamy layer. Now what is creamy layer and non-creamy layer under OBC? So other backward classes has, basically the law says that the benefit of reservation should be given to the person who actually should get it, who is actually in need. A person who's already well off, who could have afforded everything, should not be the one getting the benefits of the reservation. So for that, under OBC, two categories were created. Creamy layer means a category of people who have already had good life, and there is a certain criteria as to who comes under creamy layer. For example, a person whose parents were government officers of a certain cadre do not get reservation under OBC because they fall under creamy layer. And second is non-creamy layer, people who don't fall under that bracket and will actually get the benefit of the reservation of OBC. So in this case, a person files a case in the Supreme Court saying that I should get OBC certificate, OBC reservation. The court, the examination who held the examination committee, they said that you will not get it because you belong to creamy layer, because your parents' income are above a particular threshold. Now, the court has in a different case decided when do we make someone fall under creamy layer for the parent's salary to be above a particular criteria. But that is not the only criteria the Supreme Court has said. We also have to check the status, we also have to check the lifestyle of the person to take away the creamy layer, to take away the reservation benefit through OBC. So here candidate was treated as creamy layer because his parent earned a certain salary. Candidate said that my parent's salary cannot be the only criteria for deciding whether I am creamy layer or non-creamy layer. Now, in Indra Sani case, this was decided that we will apply creamy layer to OBCs, and so यहाँ पे can parents' income alone decide whether someone belong to creamy layer or not? The Supreme Court said no. Parents' salary alone cannot decide. We have to look at multiple factors: nature and status, social advancement of family, and the criteria laid down by the government. Only and only salary shall not decide it. All of these things will decide, and that will finally lead to the question whether the person should get benefit or not. NCERT issues public apology for chapter on judicial corruption ahead of Supreme Court hearing in suo motu case. So NCERT had a chapter in one of their books which talked about corruption in judiciary, that if judiciary is corrupt, what are the corrupt practices, how is corruption happening in the judiciary, and Supreme Court did not like this at all. The Supreme Court took suo motu cognizance for this. What is suo motu? Suo motu means on its own. Basically, wherein a judge of the court reads something in the newspaper or finds something somewhere or gets to know about that incident, by themselves file a case in the court and then call the party against whom the case is filed. So this case was not filed by anybody against NCERT. It was taken as suo motu because of course the court got angry about the fact that NCERT published something like this and then asked NCERT to apologize for the same, remove that chapter and include some other chapter. Even after one warning, NCERT did not really change as per the Supreme Court decision. So the Supreme Court also said that the persons who are involved in making this specific chapter shall not be a part in any more chapter inclusion in NCERT. So NCERT issued apology and then finally changed the chapter for the same. right? Chaliye. Supreme Court allows first passive euthanasia, permits withdrawal of life support for man in vegetative state. So Harish Rana is the name of the man. In 2013, he fell off fourth floor of his college building, and then he was in a vegetative state for 13 years. He could not move his limbs. He was taking respiration through a tube, through a respiratory tube, and he was given food by a feeding tube. So he could not take food normally, he could not even breathe normally. For 13 years his parents took care of him, but 13 years later, now this year, because the parents were getting old, they were afraid that who will take care of the person of Harish Rana when they are gone. So they really wanted that passive euthanasia should be allowed. Now what is passive euthanasia? What is euthanasia? Euthanasia means killing someone, okay? Now there are two types of euthanasia. One is passive. Passive means where you take away the life support of the person through which the person is alive, and then the person dies. Second is active euthanasia, in which you give a certain type of drug to the person to actively kill him. There is no medical support, he's okay, but you actively kill the person. Active euthanasia in India is not allowed, not at all strictly banned, but passive euthanasia for the first time has been used in this case. Basically, it comes from Aruna Schonbach case. Aruna Schonbach case happened wherein there was a woman who was in a vegetative state, and so a case was filed by some NGO that she should be allowed passive euthanasia and she should be allowed to, you know, not be in that situation. But actually her case was very different, because the court said, okay, we can allow passive euthanasia, but the doctors who were caring for her, the nurses who were caring for her, did not allow passive euthanasia on her. So passive euthanasia was not used upon her. She finally died due to pneumonia, I think in 2015, around that year. I'm not sure with respect to year, I'm sorry. But on her, the passive euthanasia was not exercised, but it was talked about in her case for the first time, that okay, we can allow for something like this. Then another case happened, Common Cause versus Union of India, in which the Supreme Court set up guidelines where we can allow for passive euthanasia. For example, we will require a medical report, we will require this and that. And then finally, for the first time, euthanasia, passive euthanasia was used on Harish Rana in this particular case. God bless his soul. All right. Now, quarrel with daughter-in-law, by itself no offense of cruelty or dowry harassment. अब यहाँ पे a woman filed a case against her husband saying that cruelty and dowry harassment has happened with me. She said that parents-in-law used to quarrel with her frequently, and now the problem is that she did not say what was the specific quarrel. She said they are quarreling, they are always bickering, they are always shouting at me. The court said, okay, give us instances that at 2 a.m. you were in the kitchen, the parents came, thrashed you, whatever. Give us specific incidents. For that, she had no answer. So the court said that you can't just come to court and say, I have had quarrels with my in-laws, just make them liable under cruelty. Court said this is not going to fall under cruelty and did not make the in-laws liable for cruelty or dowry harassment, because no specific incident was told by her. That is it for today. I shall see you all in the next session. Thank you so much, guys. Take care. Have a great day. And all right, I hope there are no doubts. All right, guys. Take care and bye.